Any mention?
Not a beg to make a mention of item 8 of the hearing list matter. It is
Item 8.
8 one. It is listed after 2 weeks.
Mr. Mahanto has no objection. Smile says that no.
He explained some difficulties.
When do you want it? Was it hard at some length? No.
No, it was not. No. After 2 weeks or 3 weeks.
Say definite
Can
something.
it,
No,
after 3 weeks.
After 2 weeks. We'll have it after 2 weeks. Just on the request of the petitioner, list after 2 weeks.
Much.
Wait, please, Your Lordship. Your Lord, I beg to mention item number 10 and 11 of the hearing list.
These are all those.
Yes. Lordship, Honourable, similar matter has been heard by Honourable Justice H.S. Thank you. And it is reserved for judgment. Please note the decision. Need to follow after that.
So 10 and 11, just on the joint request, maybe the parties list this matter after. When do we want it?
Anytime, I think. Judgment. After judgment.
When do you expect the judgment? 2 weeks or 3 weeks?
I think 2-3 weeks it will be.
Just after 3 weeks. Just. We'll have it after 3 weeks so that we don't have to adjourn.
Oblige, Your Lordship.
Diploma.
May I please, Your Lordship, I beg to mention item number 15, Your Lordship. Related matter be taken up after 2 weeks.
This is the other side.
It is actually a formal party matter. Private respondent is the main.
A notice has been served, Your Lordship, but till now they haven't appeared. A notice has been served to the private respondent.
So they have not entered it.
Yes, Your Lordship.
Already filed affidavit service.
When do you want it?
After 2 weeks, Your Lordship.
In the request made by the petitioner, list after 2 weeks.
Oblige.
Please, Your Lordship, I beg to make a mention of item number 12, 13 and 14, Your Lordship.
12, 13 and 14.
These are connected
These are all
matters.
connected matters.
Your Lordship.
Yes, what happened?
I pray for 2 weeks' time, Your Lordship. Yeah.
Why?
Senior counsel is doing some part of matter, Your Lordship, before courtroom number 2.
Other side? Who is the other side?
State private respondents are also there. State is being represented.
Do not have any objection. Just say. Here 13 and 14 should have petitioner. The land counsel for the petitioner makes a prayer for adjournment of the matter. Stop. The counsel appearing for the respondent. Counsels appearing for the respondent have no objection. Then it's a prayer allowed. List after 2 weeks.
2 weeks, Your Lordship. Your Lordship, similar prayer for item number 6, Your Lordship.
6 no objection. Item number 6, who is the other side?
State, Your Lordship.
State respondents. We don't have any objection.
Okay, just 6 after 2 weeks.
Your Lordship.
This is 2017 matter.
Your Lordship. After 2 weeks, Your Lordship.
Okay. Same order in 6 also.
Oblige, Your Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 19. I kindly pray for 3 weeks' time, Your Lordship.
No objection, Lordship.
Here for the petitioner. Okay, item 19 on the request made with the petitioner. This is matter after 2 weeks.
Will be obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 17. Your Lordship, it's a joint prayer, Your Lordship, since the judgment in the Honorable Supreme Court.
My Lord, it appears that matter is still pending in the Supreme Court.
Oh, that is a POXO matter.
POXO.
Yes.
Okay, this also after 2 weeks. So after 2 weeks.
What's your right?
Just made by the petitioner.
Lordship, may I please, Lordship, I beg to mention item number 16, Lordship.
Yes,
I'm praying for 2 weeks' time, Lordship.
you're praying on behalf of the petitioner.
Yes, Lordship.
My Lord, and for the state, I have no objections.
Yes, Mr. Sheikh, you are there.
Lordship, here I have raised the issue of juvenility. If I succeed, then matter. After that, I'll argue on merit, Lordship. I need some time, Lordship, in this case, Lordship.
Okay, say 2 weeks on the request made in view of the petition.
Please, Your Lordship, I beg to mention item 7. Item number 7.
Item number 7.
Yes, Lordship. Mr. Philemon Nombri is indisposed, Your Lordship, so I pray for 2 weeks' time.
We have no objection, Your Lordship. No objection.
Okay, 7 also, after 2 weeks on the request made in view of the petition.
Oblige, Your Lordship.
Yes.
Submit causeless. Item number 1.
The item 200, my friend Mr. Sen is appearing, but my lord, he is on legs in the other court. My lord, if this matter is taken at the end of the court, my lord.
This is a motion thing.
Motion.
Again, what is this? This is quashing of FIR.
Not for the question of the FIR here, because lordship, there was a dispute of Akhang. Because
you just remain there just for the timing.
Well,
You do not have any
yes,
dispute.
the private respondent. There was some dispute between the private respondent and the petitioner regarding the Akhang, because fact of the yes, not Akhang, plot of land. Because my contention is that since from the time immemorial, I have inherited this particular plot of land from my parents, from grandparents and from my parents, and that it has been existing. And then actually, but since it is under my positions from time immemorial, I ended, and then but then there is the petitioner did not obtain the legal document like Pata and other document from this one by the taking advantage of
Civil matter.
Civil matter. But I will come to what
why it is
Lordship, I'll come to what happened, because before that, this is just a fact of the case. Why I come to then after that, what happened? Taking advantage of the non-absence of the document, the private respondent filed the FIR against me, saying that I have taken the plot of land of there, and then magistrate that FIR was forwarded to the magistrate. Actually, then magistrate actually what happened? Actually, now they are supposed to register under 107 and 145 for proceeding. Now the proceeding in lordship is very much aware that the executive magistrate they cannot decide on merit. At least they have the proceeding, they can record the statement of the parties and they can see, but they cannot decide the title suit. And however, in this
they have not decided.
They have not decided, but in the particular they have also indicated in the order that the concerned party.
Just tell us. You see, before you come to the marriage, tell us what order you change.
The
107 proceeding or 145 proceeding or what?
Yes, not proceeding that.
Tell us that way. You see, the FIR was last. Then you also filed a counter FIR.
No, we don't file it.
Okay.
Now the FIR was forwarded to the magistrate. Okay. Some recorded was then
proceeding under
145 and 107.
You have a copy of the petition. You do not have.
Copy of the petition. Of course I have.
Anyway, if anything is needed, it's all right. It's all right.
Then what happened? Magistrate, he has attached my property, saying that till you go to directing us to approach the civil court. At the same time, he said that till that time my land.
Decide your title.
Yes.
145 will decide your possession.
Yes.
Without any reference to the title.
Lordship.
You see, who is the actual owner, who is not the actual owner, is basically irrelevant.
Lordship.
Deciding possession under section 140.
Lordship.
Okay.
Now,
only thing is that court has to determine who was in possession.
Now my contention is, Lordship, only thing is that I am ready to approach the civil court to claim my title suit. But then this order says that my property has been.
You are challenging the order passed by the magistrate.
Yes, Lordship.
So why you are before this court? Why you have not approved session court?
No, this is the executive magistrate.
So what? That is why session court will 397. Executive magistrate is subordinate to session court so far as the power of revision is concerned.
But in Dadangiri Lordship, the Lordship.
So what? Dadangiri is what? Dadangiri is there is no session court. What?
There's only the executive magistrate.
See, you are not to see your convenience, mister. If it matter can be assailed before session court, why High Court should entertain it?
Lordship,
you are appearing in this matter.
For the statement.
Because the 482 and 390 even
482 397 order is revisable under 397. Go to session court.
No, the Lordship even
this order passed is assailable before session court under 397.
397 even the High Court can interfere, Lordship. Because
if session court cannot interfere, High Court will not interfere. Go to session court. The concurrent jurisdiction. Go here. What is the order? Just tell us take us to the impugned order.
The impugned order dated page 3.
Yes.
No, page 19, Annex 3.
Yes.
Share receipt on transfer and pursue both party present with counsel after pursuing the case record, the following observation.
Who are you? You are first party or second party?
I'm the second party.
Skylin M. Sangma.
Skylin M. Sangma.
There are three second parties. You are all three.
We are
all three are
here,
before us.
Or yes, all three are before here.
Why state is the party? Just because we forwarded the
Lordship, and see, kindly see who's the party as far as the state is concerned. Is the Chief Secretary, not even the Home Department, not the police station, not the OC, not the IO, but the Chief Secretary.
that can be corrected. Once Chief Secretary is there, everybody is there. See, that is a problem. Anyway, but then the state does not have much role.
We have no role really,
except for forwarding that thing.
Correct.
Recommending withdrawal of proceeding under 145.
Yes, that's all.
But then so far as this order is concerned, state does not have any.
State country, it's a judicial order.
It is not
Is it not
judicial.
that this order is assailable before session court? This is assailable.
That's why he's clubbed 397 with 482.
482 is meaningless. Once there is a procedure available in law, 482 cannot be restored. See,
And just to point out, this is an order of 1st April 2022. He's before this court after 2 years. No explanation for the delay.
Is it?
Lordship, the impugned order is at page 19.
Yes, it is dated
1/4/22.
Mr. 397, you just want to, you see, escape the clutches of limitation. Now law of limitation is made applicable throughout the state of Meghalaya. Just to escape that, you just quote 482 and invoke jurisdiction in this court. This court will not entertain. You go to session court, file appropriate petition here. Why 482 should be invoked here?
Here because we are aggrieved this particular.
You are aggrieved. Go under avail with this thing under 397. Why 482? Just because you incorporate 482, what is the question of limitation there?
Because the proceeding, Your Lordship, that there is a legality in the order passed by.
The question of limitation will come. First you correct yourself, then you point out to the defects of others. Your approach has to be a correct approach, isn't it? As Mr. Shen has pointed out, this court had basically was under the impression that is a recent order.
Recent order.
It's 2022 order, and after 2 years you are coming. And now the law of limitation is applicable throughout the state of Meghalaya. We will not entertain this application.
I withdraw, Your Lordship.
You withdraw
with a liberty to approach the competent court.
That is better. You should have pointed out that part. There is a 2 years old order, you see. You just, if I 397, see 397. The executive court, executive magistrates are subordinate to session courts for the purpose of 397. Is it? That is there is the explanation. Is it? There is the. Heard Mr. P.T. Sangma, London Council. P.T. Sangma as well, Mr. S. Chan, London GA at some length. After arguing the matter for some times, the counsel for the petitioner made a prayer to withdraw this criminal petition with the liberty to approach appropriate authority. That will do your purpose. You see, we do not want to shut down from these things. You should have that scope of challenging. We'll just what you said after having what I said. After authority. Stop. In view of the submission, this petition is this criminal petition dismissed on withdrawal with liberty as per withdrawal.
Lordship.
Much for Lordship.
Daily list, item number 1.
Yes.
Your Lordship, I humbly pray this matter may be taken up after 2 weeks, Your Lordship. Similar matter is pending before the revision bench.
Is it? You are there.
For the state.
Is there any matter pending before division?
There is some matter, may have some bearing on this.
That division bench matter has been heard. Already has been heard.
Not here, Your Lordship.
Not referred yet.
But then it will have a bearing on this.
It may have a bearing on this.
May have, not very
May have
sure.
a bearing on this. They're challenging the power of the district council to issue pattas. Because the patta has a stipulation.
Acha, that there is a PIL. There is a PIL file.
Not PIL, it's a writ of petition. It's a writ petition. They're challenging the GHDC rules.
This court sitting in a division bench had come across such petition. I think. Anyway, there are 1 or 2 petitions, I think, of similar. So it may have a bearing, so we cannot say that it will have a bearing, surely. We'll just say that's the request made by the petitioner. This is matter after 2 weeks. Or just you say the counsel for the petitioner makes a prayer for adjourning the matter by 2 weeks. The counsel appearing for the respondents have no objection. No objection, isn't it? I'm asking Mr. Devnath. He seems not very happy, so prayer allowed. Just after 2 weeks.
Much.
Item number 2.
May I pray, my lord, this matter be taken at the end of a boat?
Why?
My lord, Mr. Paul is supposed to do this matter. He's on his legs in the other courtroom, my lord.
You were competent enough to take up the matter. Why to?
I'm, in this matter, I'm only to the extent
Sometimes
of
you are
assisting.
better than Mr. Paul. He's not here, isn't he? Do not
He's
tell
not
him
here,
that
my lord.
one.
He's in the other courtroom, my
That's all right. But then the comment of the court you do not convey to him. You will be angry. Anyway,
We can have it at the end of the board, my lord.
what is the matter about?
This matter, my lord, we are challenging an order of the learned trial court, my lord. Here, rejecting our application under 311 for re-examination of a witness, prosecution witness, my lord. Here, here, my lord, the
311 next. The rejection of application under 311.
311, my lord.
Okay, at the end of the vote.
Item number 3.
Your Lordship.
Yes.
Yeah, I could not file objection because it is very hard to contact my clients. He is in South Garo Hill. I tried to contact him, but he is not responding. So I have done everything but to get his signature only. So
Are you sure you will be able to contact them, or they are not interested?
No, I am trying to contact through his relative.
So you are not very sure whether you will be able to contact them or not. Are they really interested to contest the matter?
He is interested, Your Lordship. So grant me, I have taken consent from the other party also, from the counsel of the petitioner, Your Lordship. So he is busy in election also, Your Lordship.
So how much more time you want?
After 19 MP election, Your Lordship.
Last opportunity will be given, Lordship.
You have agreed to his thing, why last opportunity is there? Then you should oppose. Once you consent to his...
So I kindly grant, Your Lordship. After 3 weeks. 19 is the MP election, Your Lordship.
So it has to come after 3 weeks. If
Yes.
4 weeks means 18th.
Yes, Your Lordship.
Okay. LM Sangma, Learned Council appearing for the respondent. 6. Praise for grant of some more time for filing an objection in the matter. Stop. The prayer has not been opposed by the learned counsel or the petitioner. Then you say prayer allowed. We'll list this matter after 3 weeks. We'll give you 3 weeks, but then please
Yes,
do it.
yes.
If they are not
Your
interested,
Lordship.
then
Yes, Your Lordship.
this is a criminal petition. We can hear it without any objection.
Yes.
Item number 4. Item number 9.
Lords, this matter.
My lord, before my senior proceeds, the current counsel is on next before courtroom number 3, my lord.
Who is appearing here?
Mr. Andy Shulai.
Well, I was also praying for a little accommodation in this matter because there's a connected, not really a connected knowledge on similar issues. There was a PIL that was disposed of by the division bench of this honorable court last year. Now, where certain suggestions had been made by the petitioner in that particular case, which was accepted by the state, whether that has a
In the
bearing.
PIL, the petitioner is a party.
No, petitioner was not a party, Millets. The issues are with regard to transportation of cattle, Millets, and the adherence to the Prevention of Cruelty Act and certain SOPs under that. Now, in that particular PIL, certain suggestions were made by the petitioner there on similar lines, my lords, regarding protection of these cattle, which was accepted by the state and finds mention in the final judgment of this honorable court. Well, as we wanted to examine that and place it before your lordships, whether then anything would survive in this matter or it would be covered by the judgment of this division bench.
Okay, we'll just. So, because there's a request from
state.
So we'll just say on the request of both the parties, just say on the request meet with the parties. Well, this is met after 2 weeks.
After 2
weeks. Right.
Please see it if there is no.
My lords, if it has already been accepted, my lords, nothing would survive. Because what happened is the Supreme Court, my lords, had framed certain guidelines on the basis of which an SOP was circulated by the ministry. Now that was
Not followed, not adhered
not
to.
followed, adhered to in the state. But subsequently, my lords, the other PIL came. So I don't know whether they have now adhered to that. Right.
Item number 18. Call. Item number 2.
Just you see this book right there. Just. Yes.
This matter pertains to a application under 311 filed before the learned trial court, seeking for recall of certain prosecution witnesses. The facts are that what had happened is initially the witnesses were examined, the DWs were also done. At the stage of DWs, that's when the petitioner had taken the plea of an alibi. In his 313 also, the plea of alibi came. Unfortunately, at the stage of the prosecution witnesses, this aspect of the alibi aspect was not looked into by the earlier counsel who was conducting it, and on that ground, an application under 311 was filed for recalling a certain. I think 4 witnesses were supposed to be recalled. To that limited extent, an application was filed.
Defense witness.
Prosecution witnesses, for cross-examination.
The plea of alibi is by you.
Plea of alibi is by me,
Then
those people were particular to that aspect of establishing the plea of alibi. Unfortunately, at the stage of
for establishing plea of alibi, that is the onus is on you, isn't it?
The onus is very much on me.
Basically, you will prove it by the defense witness.
What is the
question of calling prosecution?
The prosecution witness were not put with certain questions which would have established the plea of alibi. That is the only reason why we had sought permission to recall those certain witnesses. Now, while that was pending, the learned trial court dismissed my application, saying that at a belated stage, the 311 application has been filed. Even though he holds that an application under 311 is very much maintainable, he says that it is filed at a belated stage, so therefore, this application under 311 cannot be permitted. And your lordships are aware, the 311 actually permits the recalling of witnesses who have already been examined.
That is all right. There is no dispute to that.
Lordships.
But then doesn't mean that they say like each and every application should be allowed. It is basically for the trial court.
It is, The trial court does not go into the merits of
fact.
I'm sorry,
It is for the trial court.
True,
Before allowing or rejecting the application.
But your lordships are aware, that the scope of 311 is on the larger interest. That is in the larger public interest, if the court or any of the parties feel that for the purposes of proper adjudication of this matter, an application under 311, certain witnesses, certain relevant aspects have not been put or they have not been tested on those, they can be recalled under 311. The learned trial court simply says, that because it is filed at a belated stage of 7 years.
Where is the order?
I'll take your lordships to the order. Starts from page 73.
What is the stage of the trial?
It is fixed for final hearing.
My lord, as per the CIS, my lord, it says it's fixed for hearing on some interim application. My lord.
All the interim applications have been rejected, so it has to be for final hearing.
This is what the CIS says, my lord, which is listed today.
My instructions are it is listed for final hearing today.
No, but then what is that? He says that it is fixed today for consideration of some what application?
My lord, this is what the CIS. My lord,
CIS
as per the
may not be
my
correct, my lord. CIS may not be correct.
Interim hearing, my lord, it says.
What is the stage of the case?
It is fixed for final hearing, my lord. 313 is recorded.
Otherwise, everything is over, my lord. Evidence, everything is over.
Now 311 is out of what? Just Mr. Paul, just clarify one aspect.
My lord.
313 is over.
True, my lord.
Now 313, the court has the authority to ask question.
In that, alibi has come, my lord.
To an accused.
True.
At any stage of the trial.
True, my lord.
Or after conclusion of the prosecution witness.
And defense witnesses, they've done that. 313.
You see, taking into consideration the evidence and basically purpose of 313 when it is taken up at the end of the after the conclusion of the prosecution is basically put all the situation which are appearing is the accused to him.
My lord.
In order to enable him to offer his explanation.
My lord.
Now, after the amendment of CRPC and all, now 313 questions are prepared after taking into consideration the concept of the prosecution as well as the defense.
Lordship.
Now, once you do it, once you complete it, where remains the scope of filing a 311?
My lords, That is where, my lords, the law is very clear.
See,
That
at any
even in
stage, if you say
313,
311 at any stage,
my lords,
does it mean that when after the matter is heard, even reserved for judgment,
yes,
that
my
also
lords,
at this stage
that,
also it
that's
can
what the
come?
Honorable Supreme Court says. The Honorable Supreme Court says, my lords, that as long as the matter is in session by a court, an application under 311 would be maintainable because of the simple reason, my lords, it's in larger public interest to determine whether, my lords, any material aspect of that matter can be extracted from any witnesses or whether that has been left out.
And now, if the 311 application is allowed,
My lords.
then you'll have to again examine under 313.
Well, it's 313 in
It may happen like that.
May, my lords. The
Witness
court,
may
the
not
court may
depose.
feel, my lords, appropriate that in view of this fresh discovery.
See, the witness may not depose as you expect.
My
See,
lords.
may not be to your expectation.
True, my lords.
It may appear he says something which rather incriminates him. So it goes against him.
My lords.
And then there becomes a need to put the situation to the accused.
Under 313 again, my
So
lords.
then there will be again reconduct of 313.
That aspect I'll have to.
Please, you have to see, these are all queries by the court. Now,
True, my lords.
you being a senior counsel, this court will have.
We'll try and assist your lordships on this.
Expectation from you, at least to clarify, because
My
you
lords.
see, so far as this aspect 311 is concerned, there are numerous judgment by apex court.
My lords.
You see, but then so far as the stage or the situation or the, you see, like basing on which that should be allowed or should be rejected, that remains an arena which is still fluid. Like there is no definition.
It would be on the facts of the particular case.
Basically, is for the purpose of ensuring the ends of justice, that you see, like the truth in a criminal proceeding.
My lords.
That is what the purpose is.
My lords. Because, my lords,
So
here.
whether it should be accepted or rejected, basically that discretion
My lords,
primarily rests with the trial.
if that matter had been rejected on the ground of, my lords, on the merits of the matter, then your lordships are absolutely correct. But on the ground, my lords, that it is filed at a belated stage.
Is it the only ground?
Well, that's what the learned appellate court holds.
What's the order?
The operative portion, my lords, I'll take
Where
your
is the
lordships.
order? It starts at?
The order starts from page 73, my lords. Operative portion is at page 91. If your lordships kindly come to para 9.10.
Oh, it's a big order.
It's a long order, my lords.
So we may have to go to the whole part.
We'll have to read the entire order, my lords, but I'll just very quickly take your lordships to the operative portion at page 91. My lords.
Yes.
Paragraph 9.10.
Yes.
My lords, finding out truth for just decision is indispensable in a criminal trial. However, the journey has to be procedural prescribed by law. The checkered facts of the accused's case reveals that there are glaring materials on record to manifest that after examination of the accused under 313 of the CRPC, he had sufficient opportunity to take corrective steps under proper guidance. However, he has chosen to express his ignorance of his rights. After a lapse of 7 years from the date of aware of his rights to defense properly, the accused has chosen to repeatedly extract his rights, which amounts to abuse of the process of court. If it is a case
Why repeatedly? Why is repeatedly? It means like there was a.
Earlier also, my lords, an application had been filed. The problem here was, my lords, that this accused was originally defended by some other counsel.
No, if earlier, see, now, can it be basis? That change of
No, my lords, what had happened is in 313, my lords, the court puts a question of alibi. Alibi comes in, my lords. It's not that something it has been manufactured at this belated stage. Now, I would not, why I'm reading para 9.10 before your lordships is, my lords, because this is the ground on which it has been rejected. Merely because it has been filed at a belated stage, my lords, whether it would be...
No, but then he said repeatedly, it means there were some application before this also.
Applications were filed, my lords, but they were not considered. So it is not that I've slept over my rights.
No, if these applications were filed, it were not considered.
My lords.
Then why, what is
Because earlier also, my lords, my DWs were closed. I had to come before your lordships, my lords. Your lordships permitted me to lead DWs. That's when the DWs were permitted to be led. After that, when 313 came in, my lords, the plea of alibi was actually, my lords, I was confronted with the plea of alibi. So when we said, my lords, that those witnesses, it is crucial that those witnesses be...
Where is your plea of alibi?
Well, I will just take your lordships to the... What's the 313? Pitch. My lords, we filed an additional affidavit. Your lordships would find it at page
The
47.
court says you have filed successive application on the same ground.
The first application, my lords, was not, what I am instructed, my lords, it was not pressed.
Basically, these are the findings. If it is there, we will not go into the thing whether this is a correct findings or not.
True, my lords.
Anyway, just show us your plea of alibi.
My lords, yes, please, my lord. 2 and 3.
Where, on what basis you say that there is a plea of alibi?
Just a second. Your lordship, just bear with me for a second.
Mr. Paul, we may have to go through the entire order.
I'll have to take it. I'm just, my lords, trying to just
some observation in other paragraphs also.
Court has to defense pointed question on plea of alibi.
Where is Vishal? Where is he? You can go, you can type it if you can send him. If he is finished, just see. Instead of wasting your time, you can utilize because may have to be corrected also. It's a long pending case.
Well, it's just long pending matter, my lords.
You were examined under 313 in 2016.
16, my lords. Thereafter, my lords, the matter has been lingering on because of the prosecution. That is something that I wanted to point out before your lordship.
See, it is lingering and all. If you at all say that there is a plea of alibi by you, could have filed this application after immediately thereafter. 2016.
Well, that is the ground on which the learned trial court actually rejects the entire
In
application.
such a case, that is a correct decision. We will not interfere in that.
Well, so my little difficulty is my instructing counsel is not here. So we try to just get instructions, Bellows, on this. This is the rough parameters on which the case is, Bellows, and what I've humbly stated before lordships is...
What about your plea of alibi? That thing you
Bellows, we just try to point that out, Bellows,
see,
where it has
the
come
plea
out.
of use it as a plea of alibi. There's a manner of taking it and how
It has to be taken.
See, it is not that just because you say I was not there, it becomes a plea.
That does not
That
matter about, and somebody would have to establish that also. Whether that has been
plea of
done.
alibi is something that you say that I was in some other place at that point.
And that person, my lords, would have to vouch for that.
So otherwise, just if that there is a denial on the part of the or the statement of part of the accused in 313, and he says that no, I was not there at the place of
that itself would not constitute a plea of alibi.
Not at all.
My lords, that would not constitute plea of alibi.
So that is what first, if you just point it out those things, then it will be.
Lords, may I pray your lordships have it on some other day, my lords, sometime week after. Then in the meantime, I would also run through the entire records, my lords. I can assist your
It
lordships.
appears this order, there are many things against you. You have to take care of. We go through the whole order.
My lords, the preceding paragraph, my lords.
This not only the one finding, there are some other findings also.
My lords.
It says that you see, like you have suppressed many things, the many. So
Lords, I could not have suppressed, my lords. I was in custody.
Whatever it is, you see, this you do not mean that you see somebody appearing on your behalf also. If you say something, it will not mean Mr. Paul has done.
No,
You have not
about-
committed any crime, you see. When we can have it, Mr. Paul?
Could we have it after a week? Well, it's the week starting 22nd, subject to your lordship's convenience. Or the week starting 15th or 22nd.
15th.
I think 17th, 19th is again a holiday.
So we'll have it. You see that there will be election time, and probably I do not know the availability of other courts also.
Lordships.
I do not know. There may be.
There's this commission. The lordships applying to
go
visit.
for inspection of
Inspection to
airport
the
and all those
airports.
things. We do not know there will be change in the roster or not for that moment. You say like the moment we go this time.
2 minutes.
So we'll do one thing. We'll have it after 2 weeks, so that 19th is also over.
So you could probably have it on the week starting 22nd minutes.
If you do not have any difficulty.
No, minutes.
You can have it after this month. Yes. Just say on the request of Mr. K. Paul Leonard, Senior Counsel for the petitioner. This is matter for 2 weeks.
We can also place before your lordship, which is the exact stage of
And
trial
it
at this
seems,
stage.
Of course, this court has, but then the few pages.
Malits.
Just now, this court has gone through.
Malits.
There appears to be
I'll have to
quite-
deal with that, Malits. I'll have to deal with those observations.
You also please prepare.
Mallet.
And do not say later than you are not prepared on this point.
No, Mallet.
Do you have any other one? Do you have other things?